morning, everyone. Welcome to the First District Court of Appeals. We have today two cases up for argument, and the first case is State v. Rainey. That's case number C230055. And obviously you noticed that Judge Bach is not here. She's unable to be with us today, but she will be watching arguments on video and will be participating in our conferences. So just to let you know. So we have State v. Rainey. I know for appellant we have Mr. Ehrenstein, and for appellee we have Ms. Adams. I was informed that you all wanted to submit.
Well, if I may.
Yeah.
Beth was supposed to do the argument.
Okay.
And she came down with COVID yesterday afternoon.
Okay.
And I think Neil Catial already left the city, so I couldn't get him to argue the case.
Sure. Doggone, that would have been fun.
That would have been awesome.
I know.
Obviously, I've been kind of thrown in the breach. I did read the briefs. I couldn't do an argument if you want me to. If you have questions, I'm certainly more than willing to answer the questions. I think there are some stark differences between the instruction that was given and the instruction that should have been given, but I'll leave it to your discretion.
Well, I think we're going to just leave it to your discretion if you want argument.
Okay.
I mean, if you want to submit on the briefs, we've read your briefs. But if you want argument, we're here. We're ready to go.
Just a few points I'd like to make.
Okay, great. Then, you have 15 minutes. I don't know if you want to. Do you want to reserve? Okay, if you're not using, then you can use the rest for rebuttal. And before you get started, I just wanted to go make sure everybody's here for the other case. In Re RC is the second case, case number C220660-661 and C230030. And who do we have for Ms. Boland? Is it Boland for the appellant? Yes. And Mr. Donovan for appellee. Yes, ma'am. Wonderful. Thank you. All right. Okay, so we'll start with RC. And I'll keep your time, Mr. Ernstein. I'm sorry, I said RC. Rainey.
That's okay. Obviously, I've read the briefs, and I did read the transcript initially, and Ms. Conkin did write the brief, and I think the brief pretty well explains everything. But what I just wanted to emphasize is that I think the difference between the instruction that was given, which was able to exercise dominion and control, versus actually exercising dominion and control, is not a subtle difference. I think it's a stark difference, because when you talk about able, what you're essentially doing is you're taking the knowledge element out. I think you're reducing the burden of proof that the state has to establish for the jury by simply making it able. And when I looked at it last night, I'm thinking, when you talk about able, it sounds to me more like a preponderance of the evidence type of thing rather than proof beyond a reasonable doubt. And I think that was clearly a misstatement of the law. And when you look at our particular district, in which I think I counted there were 9, maybe 7 or 9 cases which have used the language that we encourage the court to use, which is actually exercising dominion and control over the item that is alleged to have been in the place. I think that's important. And by doing what they did, I think they took that element out.
Doesn't OJI use able
I
to?
don't believe it does. I think it actually uses exercising dominion and control.
Okay.
All right.
But I guess there are cases, though,
There are a few
that
cases.
say able to.
Yes.
And then when I was looking at the instruction, you're saying it takes the knowledge element out, but the instruction actually includes a knowledge element. It says that the person was conscious of the presence of the contraband.
Well, by using the word able, okay, I think it's disingenuous to say able and then to say actually have knowledge. It seems disingenuous to me. I think if you actually say that they are exercising control over it, then they know what's going on.
Sure.
But under this-
Exercising seems to include knowledge.
Correct. But I
And-
don't think able includes knowledge.
It doesn't,
Yeah.
but the instruction, it seems like she just parsed it out and she said, you have to be able to, and then you also have to know that the stuff is there. So it seems like that combination encapsulates exercising.
I disagree. Okay. The reason I disagree, I think if she had said exercising dominion and have knowledge, then there wouldn't have been a problem. But I think you're basically telling the jury that maybe he could exercise, or maybe he had knowledge, and I think it becomes a little difficult for the jury to parse out what's going on.
How could you exercise control over something if you don't know it's there?
You can't.
Well, right. Okay.
You can't. And if you think about it, and if you think about it, if you knew it was there, then possibly it could have been a permitting drug abuse as opposed to actually being involved. But I don't think that was ever negotiated with the state. We obviously didn't try the case, so I
Right.
can't say what the negotiations were. With respect
But
to
you don't think that the addition of
knowledge
the
element,
fact that the person has to be conscious of the presence of the contraband satisfies this issue? I mean, it's all in the same instruction.
I think what it does, as I said before, is it becomes somewhat disingenuous. You're telling them maybe, I mean, it seems inconsistent to me. You use the word able and then use the word knowledge. That's what I'm saying. That makes sense. With respect to the failure to object after the instruction was given, I think the plain error analysis would apply here. And with respect to ineffective assistance of counsel, what was striking to me is that we cite 3 to 4 possible incidents in which he was stopped. And what's interesting is trial counsel objected the first time, and I believe the objection was sustained. But then it kept coming up again and again and again, and counsel did not object the next 3 to 4 times that this so-called stops were made by law enforcement.
These
So-
are traffic stops
Traffic
where they
stops,
searched
for
and didn't
drugs.
find any drugs.
Correct, but they were obviously investigating him, and then there was issues with surveillance, which didn't include him. So there were a variety of issues, which I was surprised that counsel, who I know to be a very experienced counsel, didn't object to a variety of these things that were taking place.
Well, it seemed like he was kind of leaning into cross-examining on the fact that,
Right.
well, yeah, you stopped him, but there were no
yeah.
drugs,
Yeah.
to demonstrate that they had the wrong guy. So isn't that more of like a trial strategy issue?
It could be a trial strategy issue, but why do you even want to deal with it if you don't have to? My sense is, to me, the biggest problem was there were 2 entrances to the place. And the argument that was being made by counsel was that there was equipment in the basement, but that was a separate entrance into the property, and he was never actually seen going into the separate entrance. So I think that part of the problem was he was going into the entrance where everything was allegedly stored, and that was part of the problem with that strategy. So I don't know. Obviously, it's trial strategy. I would have been more inclined to not even have it brought up, because it clearly suggests that they knew they believed that he was up to something, or they would stop him for what would, in essence, be minimal matters on the street, just to basically, do a field information to find out who he is, to find out possibly maybe he had something, and they probably believed he had something, or they wouldn't have stopped him. They wouldn't have done that. Certainly the first time, once they stopped him, they knew who he was. So the fact that they continued to stop him, and the fact that there was language used by the officer that this is how we attack and we are able to arrest high-level drug dealers, suggested that they wouldn't have been stopping him but for that. So I think, in my mind, obviously, strategy is strategy, but I wouldn't have brought it up at all. I would have been more comfortable with it not even being brought up during the trial. So unless there's any more questions, Judge Bach, do you have any questions? Okay.
Thank you.
Thank you.
And you do have time left if you want to rebut.
Good morning, may it please the court.
Morning. Attorney.
With regard to the jury instruction on the constructive possession, first off, I just think overall, the Supreme Court has instructed the reviewing courts on how to review jury instructions and is to look at them as a whole. So I think parsing this out is a little, we could do that ad nauseum on any given instruction, on any given phrase. But I think particularly with regard to this case, I cited to a Third District Court of Appeals case that did a phenomenal job of going through all of the appellate districts and actually citing to an example of each appellate district using, or finding that those instructions, both the able to exercise, exercising, or exercises, a little variation of those, but finding that they're synonymous. So I think both of those, when we look at the jury instruction as a whole, in addition to the guidance that we've gotten from the Third District Court of Appeals, I don't think that there's any merit, obviously, to that first assignment of error.
Can you help me though with, I noticed in the transcript when counsel was arguing about this instruction, the judge said something like it's not an OJI. And I found a constructive possession in OJI. So I was a little confused on that one.
Right, and without looking at the transcript, I'm not
Okay.
Sure, but I agree that I believe that what Your Honor has indicated this morning, that that's my familiarity with the instruction in OJI.
OJI is able to.
Able to.
Yeah. And it actually cites, if I recall correctly, two cases. There's I think the Hankerson case, and there's another case. I know Hankerson didn't use able to, but we don't need to parse that one out. But the other case actually does use able to.
That's my
Yeah.
recollection as well, so.
Yeah.
But I think regardless, without parsing those out, I think when you look at the instruction as a whole, there's not a problem.
Because there's the knowledge piece to it.
Correct. That's all, that the purpose of what constructive possession was conveyed in the instruction. And then I really don't need to say much, I think, with regard to the ineffective assistance of counsel claim. Clearly, trial strategy, looking at it in hindsight, what one very experienced defense counsel may do is not what another would do, but I think that the record bears out that this was purely a strategy, and his strategy was that this individual, yes, he was seen going in and out, but he was stopped several times, never had the drugs.
What was
at that time.
what I didn't understand was what the relevance of that, of the stops with no drugs, why the state put those in?
I think from the get-go, in presenting this case was to relay that this individual had been, this wasn't just we saw one hand-to-hand transaction, we ran and got a warrant, that this was something that they had been on and off for over a year, had been surveying him, if you will, like they had him
With
under
no
surveillance.
success, though, right?
With regard to actually having them on his person, but again, I think that what the evidence bears out, this was a pretty sophisticated, high-level drug operation that they had going on, and the manner in which they go in separately, they come out separately. One may have the cash, one may have the product. I think that a lot of that was borne out just with the course of their investigation. And to me, in reading the transcript, that seemed to be the purpose, was to show what his role was in this stash house or prep house that they were operating.
Well, the hand-to-hands then, I guess, if we take that, that would make sense, but the traffic stops, he gets pulled over and they don't find anything. So it's almost like they just suspected.
Right, and sometimes he had, large amounts of cash. There was also, and I don't know if this had to do, I think this may have been the stop prior to the warrant, the receipt book was found at one point in time too. So, and I think too, just the over and over again of going to that particular, and we call it a house, but I think that was a loose phrase, but going into that structure over and over again was just the course of their investigation leading up to them getting the warrant.
One of the officers testified that they were trying to, the first stop occurred because they wanted to know who he was, right? They didn't know who
Correct.
Where he was,
Yes.
yeah.
Yes. So, and all of that, again, builds upon the investigation that, again, had happened over the process of a year. And unless the court has any further questions, I would submit.
No, thank you. Sorry, you have 8 minutes.
The only thing I would point out is in our reply brief, where Ms. Conklin points out that there are 3 Supreme Court cases which do not use the able to wording. They use the actual wording that we suggest. And I think they do that because I think they realize that there can be some problems with the instruction for the jury. And they, in the Fry case, which is, I think, the case that Ms. Adams cited in her brief, the cases in there don't use the able to language. They use the actual language of actually exercise dominion and control over an object. So it seems to be an issue that's, some people say it's okay, some people don't say it's okay. But I think, when we're talking about something as significant as that he received 11 to 16 and a half years, it's a pretty significant sentence. I think we have to be a little more judicious.
But aren't we kind of also constrained by this plain error review?
Well,
I mean, the error has to be obvious.
Well, I think it's obvious if you're a juror and you don't know, able the other way. I don't know. I think it's obvious under those circumstances and clearly affects a substantial right of the defendant. So I know there's a 3-step analysis for plain error. And I think when you look at the Supreme Court cases and when you look at this court's cases, it seems to me that it is an obvious error. And I think under the circumstances, the court should reverse and order a new trial. Thank you.
All right, thank
Thanks
you.
for being patient with me.
No problem. And I hope Ms. Conklin feels better soon. And thank you both for your arguments, and we will take the case under submission. All right. Okay. Ms. Boland, would you like to reserve some rebuttal time? 3 minutes? Okay. I'll keep your time. The yellow light will come on when you have a minute left.
Good morning, Your Honors. May it please the Court. My name is Charlene Boland, and I represent RC in this case. I plan to focus my time on the first 2 assignments of error. I'm happy to answer any questions that you have. But those issues really flow from the state's delay in bringing this case. Before I move to those assignments of error, it might be helpful just to do a brief overview of the serious youthful offender process. So again, this is a juvenile sentence that the young person is serving, and then they also have an adult sentence that is sitting on the shelf. There are 2 ways that a child's adult sentence can be invoked. One is if they are in DYS, the director of DYS has to bring that motion to the prosecutor. The other way is if the child is in the community, the prosecutor has discretion to bring that motion to invoke when they feel that it's appropriate. The juvenile court retains complete discretion in deciding whether to invoke, and that's really important because in this case, the court has to find by clear and convincing evidence that the child is not able to be rehabilitated in the time remaining in the juvenile court system. And so again, that's really important because the court can find that the child has engaged in misconduct or a violation of a rule and still keep the child in the juvenile court system if they believe that the child can be rehabilitated within the time remaining.
Pardon me, wasn't RC just short of his 21st birthday?
Yes, Your Honor.
So you're saying in 30 days he could be rehabilitated despite the fact he was charged with 3 felonies since being placed on parole?
Yes, Your Honor. I
Okay.
think that it is a difficult, that's really where our issues lie, is this delay in when the case happened versus when it was brought to the juvenile court's attention, because you're right, there's not much that can happen. And
Well,
I think the
assume
kid-
they would have brought it on the first case, then they would have had 6 months to rehabilitate.
Yes,
him.
absolutely. And in 6
But
months.
that's sufficient.
Yes. 6 months, the child could be sent back to Department of Youth Services. If the court believed that there was a substance abuse issue, the court could have ordered that to happen. 6 months is much different than, I think, the hearing in this case actually occurred 3 days before RC's 21st birthday. And so that's really where the laches claim here lies. That is an unreasonable delay that is to the detriment and results in an inequity. And so-
I'm not having a hard time understanding why you're saying this is an unreasonable delay, because it's almost as if you're trying to argue that as soon as he does something arguably in violation of the law, the state immediately needs to attempt to invoke the SYO. And they didn't do that. They waited, and I guess to me that seems like a decent way to handle things, right? That they're not immediately trying to pounce and say, he needs to serve these 9 years. But after I guess that he had some pictures with guns, they didn't do anything. He had the drugs that he was charged as an adult for, they didn't do anything. And then finally another gun charge as an adult, and then that's when they finally said, okay, we're gonna try to invoke this. Like, why is that unreasonable?
Because, Your Honor, this is a unique circumstance. In no other places in the law is there this time-bound period that is personal to the child. And so the factors that the juvenile court has to consider in that invocation is how much time. That is really the crux of the claim here. And so the juvenile court can find that there's misconduct that occurred, but if the juvenile court thinks that this child can still be rehabilitated within the time that is remaining, the child can be kept in the juvenile court system. And so in this case, what we really have to look at is, was there a whittling away of that time that was unreasonable, that was to the detriment to the child, and there is no excuse for that delay.
So I guess I'm trying to understand with like the precedent that you want to come out of this court is for us to say basically to the prosecution that as soon as the juvenile messes up, that they need to go and run to the judge and try to invoke the SYO. Is that what you want this court to?
Absolutely not, Your
Argue.
Honor. Latches is not going to lie in every case. It is incredibly fact-intensive and specific, and that's what we have to look at in this case. So as you mentioned, back in 21, RC was brought into a court for a violation. He was seen on social media holding a gun. The state said it's serious and we think he should be held accountable. But that in and of itself, the state did not bring any notion during the hearing that they were going to ask to invoke. In
And they
March,
probably weren't, right, at that point. They're probably just like, okay, he messed up, but we're not going to try to put him in adult prison for 9 years over that.
well, I think what's important here is the state's now, their explanation is that the gun charge was the more serious of all the charges that he faced. The lower degree felony was the more serious one. And so that was the whole reason why they decided to file. And so my response is, when we look back over the record of this case, that just doesn't bear out with what we know what has happened in this case. And so in
I'm
March.
sorry to interrupt you, but in the, let's say, just call it the last gun case, I know the police recovered 2 firearms. In the social media, it's my understanding, there was no firearm recovered, and it may have been a BB gun.
Yes, there's certainly, the child admitted to the facts, so there wasn't an evidentiary hearing. But what the state is alleging as their retrofitted explanation for why they did not file that invocation back in March of 2022, when he was alleged to have committed 2 second-degree felonies of trafficking, was that it was the gun charge that they felt was more serious, and what really, excuse me for saying triggered them to file that invocation. And so they had all of the evidence that they needed to seek an indictment. They exchanged discovery with the adult court trial attorney in, I think it was end of April, beginning of May of 2022, which at that point there would have been 6 to 7 months for this child to be rehabilitated in the juvenile court system, which is a factor that the juvenile court must consider in making this determination. But again, the state did not file anything until 1 month before this child turned 21. The hearing happened 3 days before the child's 21st birthday.
How soon after the child was indicted for the adult gun charges did the state file?
It was a month later. It was
Right.
not simultaneous.
Okay. So, I know it wasn't simultaneous, but you're saying a month is too long of a delay?
I'm-
Or are you
I'm
saying
not-
because they waited after the gun charge?
Yes, I'm not bringing the latches claim specific to the weapons under disability. I think there are due process and violations of counsel claims for that one. I'm specifically focusing my latches argument on those trafficking charges because of that significant delay that happened between when the indictment occurred, when discovery was completed and handed over, and then when that invocation motion was brought in the juvenile court. Again, this is not going to lie in every case, but what is specific and unique here is that the crux of the juvenile court's consideration is time.
Well, yeah, and then that's another thing that you can help me out with, because, so he was in DYS and
Yes.
doing so good that they released him early.
Yes.
And as soon as they released him is when he starts to get into trouble on the outside.
Yes, he does have some issues.
Isn't the fact that, I mean, you're saying, well, if we would have had more time, we could have put him back in DYS. Well, he was doing great in DYS. His problem was when he was out in society. So why can't the judge look at that to say, well, I don't think that he could be rehabilitated because clearly we let him out and he starts breaking the law when he's out? I mean, that seems to be a part of the calculation, right?
It certainly can be part of the calculation, Your Honor, but that time period is really what dictates the juvenile court's process. What rehabilitative services do I have available to me in the time period? And so the legislature could have set up a system that says, once you go to DYS or if you get another charge, you're done. That's not what they did. They wanted the juvenile court to look specifically at the child, the services available, which could be DYS, or it could be a number of other services that are available in the community. If the court thought the child had a substance abuse issue, the court could have sent the child to substance abuse treatment, which we know 6 to 7 months is relatively within the time period for those types of treatment programs. And that time period is what's really important, because not really anything can happen in 3 days. Very little can happen in a month. A lot more options can happen in 6 to 7 months. And so
You're always going to be in that situation with juveniles when the court loses jurisdiction at 21 years old.
Yes.
So if they are committing or indicted for a crime later on, you're going to run out of time. I mean, that's just the reality of the situation.
That's absolutely right, Your Honor. And so, again, this would be a very different scenario if the young person was arrested for an alleged trafficking charge in March. The state didn't have enough evidence to move to indictment until July, August, September. That's not what happened in this case. They moved for indictment very quickly after the child was arrested. They exchanged discovery with trial counsel and then sat on that ability until nearly less than a month before the child turned 21.
And well, they did it after the gun charge, which
Yes.
was his issue was robbing people at gunpoint.
Yes.
And then he had a gun, and that's what kind of made them invoke the SYO, right? I mean, maybe the drugs didn't concern them so much that they wanted to take that 9 years off the shelf for this child, knowing that he was going to be prosecuted in adult court for the drugs.
Well, that's the explanation we have now. I think the other part of the abuse of discretion here is that this was never really contemplated at the juvenile court level, and that is unreasonable, right? When we think about this abuse of discretion, when the laches claim was put into a motion and brought up at the juvenile court hearing, the juvenile court asked for the prosecutor's stance, and the prosecutor said, that doesn't apply here. That only applies in civil court. And so none of these parts of the laches claim were ever interrogated in the juvenile court process. And so what we have is this misunderstanding of law that really started from the very beginning when the juvenile court didn't even believe that laches could lie here.
You have a case, just say quasi-criminal or criminal where latches applied.
Your Honor, this juvenile court proceeding, the invocation, the Ohio Supreme Court has held that is a civil proceeding.
Okay.
It is not a criminal
All right,
proceeding.
so
and that's
if
a
there
JP.
was an unsolved murder for 20 years, and the police couldn't figure out who it was, and they finally figured it out, would you argue that was laches?
No, I don't think we would be talking about latches. That would be a criminal proceeding. That would not be a juvenile court proceeding. But juvenile courts are unique, and so it is a civil proceeding.
Do you have a case saying that it's civil proceeding, but do you have a case applicable to juvenile court saying latches applies?
I do not have one specifically saying that it applies in juvenile court, but it applies.
So this would be the first one?
It would be.
Okay.
And I know you're at your initial time, but I actually have a question on the second assignment of error, which was pretty general as far as just basically saying the judge ruled against RC on numerous things. One of the issues was a suppression motion that was filed. And this was to suppress statements that he allegedly made without being Mirandized in the two adult cases.
Yes.
And what I'm confused about is this is a basically imposition of a suspended sentence, this SYO. It's hanging over his head. The judge has to determine whether or not to impose it.
Yes.
How is the exclusionary rule applicable in these types of proceedings? Because I haven't seen any case that says that.
Sure. And, Your Honor, I think the thing to remember here, and that was one of the issues that we raised as, the juvenile court seemed to be thinking this is merely dispositional. But what's important is that in this invocation hearing, the Ohio Supreme Court has held there has to be due process, fair treatment, and the effective assistance of
And
counsel.
that's the case for like probation revocation and parole probation revocation we'll use as an example. But courts have also held that the exclusionary doesn't apply. The exclusionary rule does not apply in those cases.
Certainly, Your Honor. And so, again, that claim is made as a cumulative error claim because what the defense attorneys were saying at the end of the day is that we have tried to advocate for our client, and at every turn we have not been given the opportunity to advocate for our client. So if this court feels like that motion to suppress that specific error does not matter, this court does not have to find piece by piece, and we really didn't create that assignment of error to go piece by piece. What we are looking at is this whole of this case. And so when the defense counsel says, I cannot be effective because I never received any of this information in discovery, that is a problem.
That's another thing I didn't understand.
Sure.
And help me with understanding what happened here. But was the lawyer who represented RC in adult court also part of the juvenile
Yes.
court? Okay. And the discovery in adult court had been turned over in those cases, right?
On the trafficking cases.
Not the gun case?
Not all of it. The body-worn camera
Okay, the
footage was not
body-worn
given.
camera was not turned over because the
Yes.
state said they didn't even have it.
Yes.
And I hear the frustration on that one. But as far as all the other discovery for those two cases, didn't the record bear out that the lawyer who represented RC in adult court did get the rest of the discovery?
When they were specifically talking about the shot spotter alert, trial counsel said we'd never received information that there was a shots fired alert. That was never provided to us. And when the witness got up there and started talking about it, that's when defense counsel objected and said, we have not been provided that specific information in discovery. And
Okay.
so how is that attorney supposed to represent RC when they're defending this child against information that they have never had a chance to vet or look at?
So there were some of it was not turned over?
No,
Okay.
not all of it was turned over.
Okay, thanks. And I'll reserve your 3 minutes. I
Thank-
had
I
a lot of
appreciate it.
questions.
Thank you.
Good morning, Your Honors.
Good morning.
Good morning. Morning.
I guess where I'll start is abuse of discretion. And it's hard to imagine that it can be an abuse of discretion to take an unprecedented position that there is absolutely no case law support of that latches is applicable in these sort of situations. So how can it be an abuse of discretion to not break unprecedented ground and to set a brand new precedent? So at the most fundamental, that would be our argument as to that. In terms
Well,
of...
if the court had done that, you'd be arguing abuse of discretion, right?
I absolutely would, Your Honor. And there's talk about the legislature and the time limits and everything like that. If latches were appropriate, the legislature could have said, you can't file to invoke within 6 months of the individual turning 21. That's something that could have been. The court doesn't lose jurisdiction until 21, but then let's say 5 months before they commit a horrific murder. You don't have that option. So clearly, and I would agree that, you know, the cases would be fact specific, but the closest they can come to any precedent for this is to say that the Ohio Supreme Court has never absolutely barred the use of a laches claim against a government entity. That's the closest that we have. The Supreme Court has said that an invocation hearing is not a delinquency hearing. This gets back to some of what you were discussing with the exclusionary rule. And while that wasn't specifically raised, some kind of responding off the cuff, an invocation hearing is not a delinquency proceeding. It is more akin to a probation violation or something like that, in which case the criminal rules, the Ohio rules of evidence, are, it's not that they don't apply, it's that they're reduced, they're relaxed in such settings. So some of the different things, you know, like in a suppression hearing or in a probation violation, hearsay testimony is permissible and those sort of things. So we would say that the exclusionary rule isn't appropriate. There's no rule that I'm aware of that allows for a motion to suppress in a probation violation. It's just not an available thing. Had this been a delinquency proceeding, then certainly those rules would have been applicable. But in this invocation hearing, the judge is absolutely correct that it is more dispositional. You know, it's clearly not a delinquency, and so therefore we would say that once again this all goes back to abuse of discretion. As to the
due process applies, and there is an argument that they did not receive certain evidence that was used against this child during the hearing.
Sure.
So isn't that problematic?
So I would agree that it could be, and that is more akin. That's not a laches argument. That's more of a surprise in terms of a criminal rule 16 discovery violation and late revealing of things. I would argue that the shot spotter, while the specific shot spotter report might not have been there, the reports that had been given was there was a report of shots fired in this area, and he was seen running from this area, and then they go to the house where that individual who ran from that is spotted going into, and they recover the weapons there.
So that information was turned over.
I would have to pull up the specific reports, but that's the entire basis
Right.
for this. And as the court mentioned, the discovery on the adult case had been provided. Whether a specific shot spotter report, you know, the decibel levels, the exact GPS locations and everything like that had been given over, I think that's more what we're talking about, not that there was an allegation
That shots were fired.
shots were fired and this individual was running. So not having that specific report would not have been necessary had we been doing a motion to suppress. The officer could have testified, I was responding to a shots fired call. You know, would there be a limiting instruction if it were at trial and he testified to that it only goes towards why the officer responded in the way that they did? You know, to explain his actions, possibly. But even in a motion to suppress, talking about that hearsay, that I responded to a shots fired call, this is the information that we were provided and everything like that. So it's hard to see how that would have dramatically changed if that report, that specific shot spotter report, hadn't been able to be attacked by expert testimony or any number of the attacks that are currently being thrown at shot spotter as being hearsay and as being, all of these different things. So the discovery had been given over. And
What about this 527B trial preparation report?
that has clearly and always been undiscoverable.
I mean, is that, because is that true, though? I mean, I thought that pursuant to case law, that it needs to go for the judge to review, to determine whether or not it's all privileged.
And that was
to
offered.
Work product.
And defense counsel, in my recollection, has said that they would proffer that to the judge.
Well, they couldn't proffer it because they didn't have it. So the prosecution was supposed to do that, and it's not in the record.
That specific issue wasn't litigated. I'm going based on my recollection from the transcript. I would have to look at who had proffered it. I believe then it would have been the prosecutor who had offered it up. You know, judge, you can review it in camera, but it is by its very name trial preparation material, and it is privileged. It's work product.
But isn't that, so are you saying that there's some sort of case that says that it's privileged, or we just presume it's privileged because it says trial preparation report?
My recollection and my understanding, and once again, we're getting outside of the parameters of the briefs. I didn't brief this specific issue in terms of that. However, it is my recollection and my understanding that trial preparation reports have been ruled undiscoverable as work product, that if there is an allegation that there is something in there, it could be submitted for an in-camera review. That was offered. I don't believe that was ever demanded by counsel. So while they might not have had it, they could have demanded that the trial court review that had been suggested by the prosecutor, that the court review it, and that the prosecutor would provide it to the court for review. That was never subsequently demanded. And any prejudice from that is purely speculative.
Right.
There needs to be some sort of showing that there was something in there other than, I want this. Well, historically, that hasn't been available. Additionally, because I don't know how much time I have and how much I've been talking, but...
You have another 7 minutes.
Oh, fantastic.
Okay.
I've got plenty of time. In terms of now saying that 6 months would have been plenty of time, that would have been time for him to be rehabilitated in juvenile court. As I believe that, Your Honor was discussing a little bit on that subject, 3.5 years hadn't been enough since the charges on the aggravated robberies. 3.5 years hadn't been enough. So what makes us think that 6 months is going to be sufficient? And 6 months is going to be sufficient to get somebody reestablished in DYS, and now we have the speculation as to a substance abuse problem, and now that's going to be sufficient to curb these behaviors. What is clear is that once he got out of DYS, within 5 months, he picked up the violation for displaying a firearm in a Facebook page. Well, they didn't move to invoke then. The state couldn't have moved to invoke then. There's no evidence, there's not sufficient proof to prove that it was a real gun. The rules of probation said that posting with a simulated gun, or even a non-working firearm, but neither of which would be weapons under disability. And without the firearm and the ability to prove that it was a working firearm that he possessed at that specific time, there could not have been. So that's a red herring.
Well, they're really arguing that the state should have moved after the drug violation.
Absolutely.
Which was fentanyl, I believe.
Yes, ma'am.
Suspected.
It was. And what I would suggest is that it is the cumulative effect of all of these things, that what is clear is that invocation wasn't going to be filed after the drug charges, that the state was going to just let it be handled by the adult court. But for the third time, we have, the first one being just the violation where he's posting, the second one being the new drug charges. Then not only is he on parole in the juvenile case, and he has that suspended sentence, but he's out on bail on the drug charges.
That's the ankle bracelet, why he had an ankle bracelet?
Yes, ma'am.
Okay.
He's out on bond on the drug charges, and then now he's seen running from the incident of a shooting, not just in possession of a weapon, not just posting it on Facebook, but he's actively running from a shooting incident. Clearly, this is the straw that broke the camel's back, and council wants us to read in isolation and only review that one, that one wasn't more important than this because it's a lower level charge. Once again, why he went to DYS, why there was a suspended commitment in the first place was using weapons. Now we have a second incident where the first one, we don't know whether it was a real gun. Now we know we have 2 real guns coming from a place where they had just been discharged. We don't know the facts of that. I'm sure that came out in the adult court, but we don't know what happened at that shooting incident. But it's clear that there was a building effect, and finally, enough is enough. Have to move to invoke. And the argument that I'm making is that that is a reasonable position to take, that it's not an unreasonable, that it's not sitting on it for gamesmanship or to try and gain an advantage in terms of a latches argument, which I would once again draw back to unprecedented. There's absolutely no case that has been cited where it has ever been used in a criminal case, where it's ever been used in a quasi-criminal case, where it's ever been used in a juvenile court case. Juvenile court, adult court, in terms of adjudicating and prosecuting criminal matters, has always been governed by statute of limitations. That's why murder, there is no statute of limitations on murder. The charge can always be brought. But on other charges, weapons under disability, there would be a statute of limitations, and that would be, as long as the state files it the day before that statute runs, the court has jurisdiction and that charge is appropriate. We would argue the same is true here, that even if it had been filed immediately with a drug charge, the possibility that when 3.5 years hadn't been sufficient, that 6 months, and it wouldn't even be 6 months because the charge would have had to have been filed, discovery would have had to have been given over, and so really the court was going to have more like 5 months to work with. That was going to be sufficient when 3.5 years hadn't been is beyond speculation, I think, and not unreasonable for the court to view, no, that wasn't going to be sufficient time, even if it had happened then. So in terms of that, even if latches were an appropriate remedy in juvenile court, and we strongly say it is not. It is unprecedented, and Judge, you're right, had the court ruled, agreed on the latches argument, and excluded evidence, because that's what it's brought up in the context of, in excluding. So it truly is a discovery violation, surprise argument. It wasn't ever specifically argued, latches, this should be dismissed. Latches, this should be excluded.
Right.
The court said, the appropriate remedy is for me to give you a continuance. We're going to give a continuance so that...
The argument was that not that the invocation hearing go away, that it was that you couldn't use any of the evidence.
Specific evidence.
Okay.
That's the context that it was raised in, both in the lower court, and I know counsel's going to disagree with me on that and say that it wasn't. But the term, if you review the motion to dismiss, the term latches in any of the cases that they're citing for the appropriateness of latches are never mentioned in the motion to dismiss. That argument is only raised in the context of the motion to exclude. That's akin to surprise under Criminal Rule 16, the least restrictive solution, and I see that I'm now out of time.
You have 30 seconds.
Oh, I thought I saw you pushed that. I guess I'll just say it would be unprecedented, and it can't be an abuse of discretion not to, forage into new grounds and to set a precedent. If there are no further questions.
Not for me. Thank you.
Thank you.
Thank you.
Your Honors, I just want to bring your attention to a couple of pieces of the information that are found in the transcript about the evidence. So on November 18th, counsel asked for the court to have an in-camera hearing to make a determination about what information was in the records. The court denied that.
For the trial preparation report?
Yes, it was the state's motion to limit discovery. They asked for an in-camera hearing. That was denied. And on November 21st at that hearing, there's multiple examples. So the EMU officer started testifying about drug skills she found when she was looking for the guns in the home. The defense counsel objected. That was not provided to us in discovery, overruled. Similarly, when another officer was testifying about the shot spotter alert and shots fired alert, objection, that was not provided to us in discovery, overruled. And then similarly, the reason why they brought that suppression motion was because they were never given information about the defendant's statement. And then when the prosecutor said, oh, we gave them just a one-sentence summary, then the court found that that was appropriate. So the suppression was really about, or the information, the focus on the defendant's statement was really about, we don't know what he said because we were never given copies.
What was
of
the
that.
one-sentence summary they gave?
I don't have that in front of me, Your Honor. I just note that
But they
it
said he made a statement admitting to the offenses, right?
Yes, but that could be a lot of different things. That's important for counsel to have when they're trying to defend their client.
I'm just curious as to is it in the record what exactly the prosecution turned over regarding a statement?
I don't know that that piece of discovery is in this court's record. I don't know that it is.
Okay.
And then additionally, on the November 23rd hearing, there was another officer testifying about the operability of the weapons. And again, defense counsel objected. We have not been provided that information. Discovery, overruled. And so I understand this court's reticence to go into the laches claim because you don't want it to seem like this is an argument that could lie in every case. But the converse is that we have a hearing that looks like this, where we have defense attorneys who are walking into a hearing completely unprepared because they're not given information to be able to defend their client. I also just want to note that the state has elected not to respond to that due process and effective assistance of counsel claim in the brief.
Well, that's because it wasn't very developed in your brief, with all due respect. I mean, it was just like the judge aired A, B, C, and D, but there wasn't any real argument about it.
Yes, because the juvenile court did not provide any reasoning. Instead, the juvenile court gave this blanket statement that made it seem like this child doesn't get due process rights because it's merely disposition. And I think that's the problem here, is that none of this is developed by the juvenile court because of these misunderstandings of law. One, that this is a criminal case when it's really civil, and that the child, by the Supreme Court's own ruling and the statute itself, says the child has the right to due process and effective assistance of counsel. And so those misstatements of law really bled down to the rest of this case. And so, sure, one of these in isolation may not be a due process problem, but when you have the entire hearing, having situations like this through the entire hearing, that was a detriment to this child. Thank you.
Okay, thank you. Well, thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.